Now, without any further delay, let's begin today's event. Again, worker misclassification, could you be at risk? I would like to introduce your moderator for today, and that is Gary Bossert. Gary, you have the floor.
Great. Thank you so much, and good morning, everyone. Appreciate you dialing in today for what should be a very interesting webinar. I am Vice President of Operations with the Medical Society Plan. This is the third in a series of employment law webinars that we've offered in partnership with the law firm Nelson Mullins, Riley and Scarborough. Today we are joined by two partners from that firm, Ann Murray. Ann has conducted these webinars for us in the past. You may be familiar with her. She's a partner in the firm's Atlanta office. She spent over 25 years advising employers regarding executive compensation and employee benefits. She's previously served as in-house counsel for a publicly traded company and offers business-oriented and practical guidance to employers. Candace is new to these webinars, and we want to welcome Candace. She is also a partner at Nelson Mullins out of the Winston-Salem office, so she's local here in North Carolina. Her practice focuses on both employment litigation and healthcare. She's worked in the healthcare industry for various physician groups and is a member of the North Carolina Bar Association and North Carolina Society of Healthcare Attorneys. So she has a unique background, I think, that will be especially useful today. As you heard, we will conduct a question and answer at the end. So again, please enter your questions in that Q&A box, and I will moderate the Q&A at the end of the presentation. Today's presentation, as you heard, is about worker misclassification. Our experts are going to discuss recent worker classification trends under North Carolina and federal laws, how these trends may affect your payroll, benefits, wage and overtime, and legal obligations, and practices you should have in place to protect your business. So I'm going to go ahead and turn it over to Ann and Candace for this presentation. Thank you, Ann. Thank you, Candace.
Thanks, Gary. Thanks to everyone that's joining us today. We're focusing on two issues that you've probably seen a lot about in the press, especially over the last 12 months, in particular the second topic that we're going to talk about, which is classification for FLSA purposes, overtime purposes. But another area that we're seeing a lot in the press and a lot of enforcement activity with both federal and state governments is employees versus independent contractors. As more and more people move from your classic going into the office type of, work style and tend to work more remote, more flexible hours, there's a tendency to offer more 1099 independent contractor status to those workers. And one of the things we're going to talk about is the risks of doing that and making sure that for your organization that you've thought through, is this classification correct, and what do I need to do to make sure that I've got the proper defenses in place? So with that, let's talk about the first topic, which is the employee versus independent contractor area. There are many different definitions of who is an employee. It can be frustrating for you as an employer because, for example, the IRS focuses on control. If the business has the right to control or direct only the result of the work, not what will be done or how it will be done, then the IRS says that worker is an independent contractor. And in figuring out control, there's no real single factor that is, the determining factor. In fact, they look at three different areas of control. Behavioral control, which would be facts that show if the business has the right to direct or control what work is accomplished, how it's done, whether do you provide instructions, training programs, do you have the person go out and get licensed with your assistance, how much oversight is there? Then there's financial control. Are there business expenses reimbursed? Has the worker invested in facilities or their own tools that they use to perform their services, or are you providing them? If you're providing them, it's more likely to be employment. Is the worker able to offer services to other businesses? Are they, for example, doing bookkeeping for you, but hey, on Thursdays and Fridays, they're doing bookkeeping for some other practice or other business down the road. And then also, how are you paying the worker? Is it on an hourly basis, or is it, by the job, by the project? The more that it's project-driven, the more likely that someone might be treated for IRS purposes as an independent contractor. And then, to what extent can this worker maybe make a profit on this business that they have going? And then finally, the third set of factors is relationship of the party. Are there written contracts? What did you agree to? Do you provide some type of employee benefits? Like, are you offering this person sick pay or vacation? That certainly looks a lot more to the IRS like an employee. Is it something permanent? If you're hiring someone for a couple days, a couple months, a set project, you're going to have a better chance of saying that this is an independent contractor. But if this is something ongoing, you have someone who's been there for 5 years, that's starting to look pretty heavily toward like it's a employee relationship. So all of these factors, as I said, no single factor is the determining factor. You basically look at all these factors, and the IRS on an audit would be giving you its own analysis and opinion, and hopefully, what you've done is you'll be able to defend. So that's what we want to focus on today is why this is important and where you might need to take another look or consider whether or not you need to revisit a few people's relationships. The second, another area where there's a definition of employee that's different than what the IRS uses is for the Fair Labor Standards Act. The Fair Labor Standards Act focuses on what they call the economic realities. So workers who are economically dependent on your business, regardless of their skill level, are employees. Once again, for FLSA purposes, there's no single rule or test. There's a whole bunch of different factors that they look at to determine what the economic realities are. But you're going to want to make sure that you've gone through those factors. And when we talk in part 2 of this presentation about the overtime rules, this will be part of it. Who you determine as an employee is going to next determine, whether or not you have to figure out are they exempt or non-exempt. If you get it wrong at this early step and you decide someone isn't an employee at all, and now it turns out they were, and hey, by the way, they were non-exempt and should have gotten overtime, it can just exacerbate the problem. So just know that the analysis is not just black and white. You have to actually sit down when you're creating new positions and hiring people to figure out, is this an employee or an independent contractor? So why do we care? Well, for federal law purposes, we're seeing a lot more focus on independent contractor misclassification. Earlier this year, even after we had a new administration come into place, the EEOC identified independent contractor issues as one of their priorities in their strategic enforcement plan for 2017 to 21. So, for the next few years, this is on their list. Even going back to 2011 and continuing to today, there's a memorandum of understanding that the Department of Labor entered into with 35 states. So the vast majority of states relating to worker misclassification, and that they're going to focus on enforcement. And then we're seeing more and more IRS inquiries into how people are being treated. I had one earlier this year or late last year where they came in and looked at an organization that, had for 30 years treated their workers as independent contractors. And all it took was a complaint from, one individual to have the IRS start focusing on this employer and asking questions about how they were classifying the workers. It took a lot of effort and unfortunately a lot of cost to fight the IRS's determination that, hey, these people, we don't care that you've done it for 30 years this way and that everybody does it this way. We think these are employees. Now, on the bright side, we were able to actually prevail in that case, but it's, we're definitely seeing clients bring this up more and more often. So what's going to happen with the new Trump administration? We've got a new Department of Treasury, Steve Mnuchin, he's formerly with Goldman Sachs. Does this mean that there's going to be a backing off or dialing down of enforcement efforts? The Trump administration has nominated a new person to the NLRB board. That's a business lawyer, William Emanuel, and that was just confirmed, in the last few weeks. But he's expected, when he goes into his position in December, to have a more of a business-friendly approach. But does that mean that we're going to see some change to whether or not they're still pushing enforcement of these things? We don't know. Only time will tell. I mean, I think as everyone has seen, it's hard to predict with the current administration, what's going to happen. And what's really important is no matter what happens on the federal level, the states each have their own power to enforce these rules. And so, from the state side, we want to look at, what's North Carolina going to do? Because you can't just say, well, from a federal standpoint, the federal government's kind of in a mess and it's not going to be enforcing anything in the near term. You've still got to worry about whether or not your state attorney general or other officials are enforcing this. So with that, I'm going to turn it over to Candace so she can focus on the North Carolina side of things and what she's seeing in her practice.
Thanks, Anne. So there are definitely some similarities we're seeing in North Carolina trending much in the way that the federal government has been trending, as Anne has just explained. I'm going to step back just a little bit and give a little background about North Carolina law that is specific to this, which we do tend to track what the federal government does with the FLSA, but there are a couple different sources under our state law dealing with classifications or misclassifications of independent contractors versus employees. There are laws under our Wage and Hour Act. I'm sure you all are quite familiar with that, which is enforced by the North Carolina Department of Labor and the Wage and Hour Bureau of that department. There's workers' comp law that touches on classifications. Of course, that's the Industrial Commission, and there's an employment classification section that specifically enforces these types of laws and classifications. And then there's the employment security laws in our state, which are under the Department of Commerce and the Division of Employment Security. As far as, definitionally, I liked how Anne explained that because it's funny with federal law, there's all kinds of different definitions, but, independent contractor under our state laws really not defined. It's kind of the opposite. Our Wage and Hour Act is probably the most comprehensive of the employment laws in the state, and you find a lot of good definitions there, a lot of good guidance on many issues that you all would be dealing with every single day with your practices and your employees. But the Wage and Hour Act doesn't define who an independent contractor is. It does define an employee, and this might be the most unhelpful definition of an employee that you would ever find anywhere. It says an employee is any individual employed by an employer. I mean, I don't know what attorney came up with that definition, but that's the most circular one I've ever seen.
I would definitely agree with that, Candace. That's yeah, that's the most vague we've seen,
It really is. You have to wonder how that made it all the way through the ranks and that came out on our law books. But that's what we have in any individual employed by an employer. So you have to look at 3 or 4 other definitions to get at the root of it. But going back to the independent contractor, because I think it's probably a little easier to sort of nail down a definition there, even though we don't have a specific statute that we really rely upon. Employment Security Law Act does have a definition, but it's not really really what we've seen our courts relying upon. What I do primarily is litigation. So, you know, I'm involved at the time when a lawsuit is filed and when we're defending, you know, against, you know, an employer, or excuse me, an employee that has filed a lawsuit saying something has been mishandled with my case or with my employment, and I need some help. So, coming from that perspective, you know, what I'm looking at a lot is how our common law has developed definitions, meaning our case law. What have the judges said, and what have cases told us, and what guidance do they have to give us a sort of test for who would be considered an independent contractor. And I think, again, we're still seeing similarities between the way we're doing it under the state and federal systems. The test in North Carolina for an independent contractor tends to center on control. So I think that goes back to Ann's point on the way the IRS focuses. The general cases say that where the party for whom the work is being done retains the right to control and direct the manner in which the details of the work are to be performed, that relationship is one of an employer and employee. So the relationship between two individuals or an entity and an individual that might classify someone as an independent contractor looks to about 8 other factors. Some of these you've heard, again, in being engaged in an independent business or calling or occupation. The specific price, is the individual doing work at a specific fixed price, or for, you know, a lump sum, or based on a quantity of work that would speak more to that individual being considered an independent contractor. Independent use of their knowledge and skills, that sort of ropes in more of the FLSA view on it as well. Is that employee in the regular employee of this particular contracting party, or do they work for others? Do they have freedom to use assistants as they see fit? You know, people to help them out, bring in others to help with the work. Do they select their own time for doing the work? Are they subject to discharge because they decide to do their work in one method versus a different method? So those are the types of factors that North Carolina specifically looks to make a call as to whether someone is appropriately classified as an independent contractor versus an employee. What we see in the states in particular in terms of enforcement is usually it happens when, so Ann was sharing, you know, an employee, could just be one employee, lodges a complaint. They might take that complaint to the Department of Labor and say, you know, these people aren't paying me correctly, and they're saying I'm an independent contractor, and that's not right. And then that spurs the Department of Labor to get involved and do an investigation, and they can bring their own cause of action in court. The Department of Labor could, or the employee might just go to an attorney and say, you know what, I've been working for this company for, you know, X number of years. They are paying me as an independent contractor, and I don't feel that that's the right classification. I'm not getting the benefits that I deserve. I'm really their employee, and I want to sue them. And then you've got a lawsuit in our state, or it could be federal courts as well. So typically it's generally not coming out of audits when these types of issues are discovered, but it's more spurred by the complaint of someone who is unsatisfied for whatever reason. And in terms of litigation, you know, it's important because these types of classification suits can be not only suits that are brought against one individual, but they can be turned into collective actions, kind of like a class action, a group of employees filing a lawsuit. So that's just something to keep in mind in terms of how this currently gets enforced. And as we note here on the slide, very, very recently, just August 11th, a new law was signed by Governor Cooper, and that law is not going to be effective until the end of this year, but the law really establishes a new section of the Industrial Commission, and that's going to be known as the Employee Classification Section. Now, if you go to the Industrial Commission's website or you contact them, they will, or talk to them about it, I mean, they will tell you, their position is this is not really new because we've had this section for some time. You know, they will say that it's not technically creating a new section because this initiative was started back under the administration of Governor McCrory at the very, very tail end of 2015. And however, at that point, it was just an executive order, but now, just this year, it has been codified into law. The General Assembly has adopted it, and the governor has signed it. So now there is, under the law, a newly created section of the Industrial Commission for this employee classification. So to Ann's point about enforcement increasing, that's exactly right, and I think that's very true here as well, because now we have such attention being drawn to this issue that a whole new section of enforcement is out there. The law itself is not really changing anything substantively about the way employees or independent contractors are classified. It's not changing anything from the perspective of, you know, creating really necessarily new burdens, although there's one small thing that it does, and I'll get to that in just a moment. But the whole point of it is really to allow the sharing of relevant information between some of these different agencies that I've mentioned so that there can be coordination of efforts. So, in other words, if the Industrial Commission, you know, receives information, conducts an investigation. This law is apparently intended to help make the next step in the sharing of that information with the Department of Labor or the North Carolina Department of Justice or the Department of Commerce a little more streamlined, so that the related agencies can be sharing this information between and amongst themselves. And it's been called basically an attempt to kind of more aggressively pursue, you know, employers who might make a misclassification. That's, of course, the sort of the understood intent. Nothing has happened yet. It's not yet in place. So what actually happens once it is in place is, of course, remains to be seen. And again, there's nothing in the law that changes any penalties or any rights of action that a person may have if they have been misclassified or believe they've been misclassified. But certainly it's at least fair, I think, to assume that it is drawing some attention to this issue, and it is becoming an issue that is being put on the forefront of a lot of folks' radars. And so I think that's important to be aware of and to keep in mind. I thought it was interesting, there's a statistic from the Industrial Commission. They have noted that complaints of misclassification for the first and second quarters of 2017 that they've received were up over 644% from the same two quarters in 2016. So just in that 1 year. Now, I don't have raw numbers. They didn't provide raw numbers for how many complaints that is, but that's a tremendous leap. And Ann, I don't know if you've heard of any other similar leaps or if that kind of increase in complaints is anticipated anywhere else where you've seen. But I thought that was a real shocking number.
Yeah, that's a huge percentage. I mean, we're definitely seeing that in other states and on the federal level as well, just an increase in complaints. And, also more of a focus from the plaintiff's bar, from attorneys who are seeing that this is an area where they can bring, class actions or, there's some possibility for a profit from a litigation perspective. So, yeah, we're definitely seeing an increase.
That's right. That's right. And I'll talk about that a bit more in just a minute. But I think it potentially could be lucrative for some of these types of plaintiffs' attorneys that handle these kinds of cases. And we'll talk about that a bit more in a minute. But I don't the raw numbers I haven't been able to trace down. But I thought that was just sort of a shocking number. And so that's about the 1-year period where this employee classification section has been in place, though not codified. So we might see another increase because, again, now it's codified into law, and it's kind of really getting attention that it didn't get as much maybe when they just sort of snuck it in under an executive order. But I do think that that's something to keep in mind. And there is one requirement I do note on here. The employers are going to have to start posting a notice for basically a poster. And I know you all have tons of these things around. You've got OSHA posters. You've got all kinds that are stuck in all your little corners and in the break room and everything in every office, and it's like, gosh, how many more posters can I possibly, get laminated and stick up here? But we're going to have another one, and this poster is basically going to have to tell people, look, if you are basically educating them on, who employees are, who independent contractors are, and what their rights are. So, saying, to the employee, look, if you're defined by statute as an employee, you're going to be treated as such until you are determined to be an independent contractor. And if you believe you've been misclassified as an independent contractor, then, you have the right to report your suspicions, and you would report those to this employee classification section of the Industrial Commission. And then here's all the information. Here's the address. Here's the phone number. We're going to make it easy for you. Go take your report and initiate it. So, of course, I think that folks are reading this and kind of opining that, again, you're going to start seeing even greater increases in the number of complaints because you're now telling people, hey, here's something else to complain about, and here's how you do it. Now, to what extent your independent contractors are seeing those and actually reading those and taking the time to look at those, it does remain to be seen. But I think that enough attention is being drawn to it that, we might start seeing an uptick in complaints and how that translates, later into actual lawsuits or how that translates into any penalties or fines or otherwise. It will remain to be seen, but certainly it's something that's being put in the forefront. Risks of misclassification. You all know this. I mean, employees, have to have, certain withholdings. Employers have to withhold your appropriate taxes, Social Security, unemployment taxes, workers' comp. If you don't do that, if you have an independent contractor and you're not appropriately making, the required withholdings, then that's going to be a problem on a number of fronts. We certainly know that, employees do enjoy more legal rights than independent contractors, which can make it for some, an attractive and unfortunately sometimes, intentional misclassification. I mean, there certainly are instances of that happening because then, that independent contractor doesn't have to be paid that minimum wage. They don't have to be given, health benefits, which are, of course, an asset right now, and such a privilege to have sick pay, leave under the Family Medical Leave Act, medical coverage, anti-discrimination. I mean, those types of things that don't apply to independent contractors are things that if someone thinks they're being misclassified as an independent contractor, they're going to want those. So there's definitely an incentive to everyone to, if they can be classified as an employee, to do so. And I think people are going to be willing to and wanting to fight for those classifications and for those additional rights.
And Candace, we're really seeing, I think one of the areas where people don't think about how big the impact can be is on the Affordable Care Act. Like it or not, the Affordable Care Act is here at least to stay for a while, and it applies to any of you listening who have 50 or more full-time equivalents. So that would be a combination of your full-time and part-time employees. So if you're in that group, and I know a few of you listening do fall into that group that's large enough, you know, if you have part of your workforce classified as independent contractors and you're not 100% sure that, hey, this is correct, if there's enough of those people, in other words, if they are more than 5% of your workforce, if someone were to come in, whether it be the state of North Carolina, you know, Industrial Commission, or on the federal level, and they reclassify those people as employees, well, now you didn't offer them health coverage, which means you won't satisfy the 95% offer requirement the Affordable Care Act imposes on employers. And the big deal there is that doesn't mean that you're just liable for the penalty for that particular worker. If you violate the Affordable Care Act, it swoops back and penalizes you based on your entire workforce. So if you have, let's say, 100 employees, 100 workers, 95 you treat as employees, 5 of them you treat as independent contractors. Now it turns out that those 5 independent contractors are incorrect. Now we're going to take 100 times $2,000 per year per employee and multiply all of that together to come up with a $200,000 a year penalty, slightly less because you actually get to offset a few people. But the point being, it actually can kind of morph into a larger impact without even realizing it.
Absolutely, absolutely, Anna, and I know that's something that folks are going to be sort of struggling to wrap their heads around now with all the changes that have been going on.
Yeah.
You know, with respect to, you know, the state-specific, I mean, there are also penalties that you can face for worker misclassification under the Department of Labor. North Carolina Department of Labor has fines for a number of things, including even just, you know, improper, you know, record keeping of your employees and independent contractors, and those kinds of fines can add up. And then certainly litigation, if litigation ensues, just the nature of litigation itself is that it tends to be long and protracted. I've had a couple of Wage and Hour Act cases go to full jury trials. They were not employee classification cases specifically, but they were under that same statute where we receive a lot of this guidance and where some of these statutes do apply. And, you know, when you get into a lawsuit in state court, you're looking 1.5 to 2 years or more for that case to go all the way from start to finish. Even longer in our federal system, it moves a bit more slowly. So just the protracted litigation expenses are quite expensive, even if you're totally in the right and win in the end. It can be quite expensive under our Wage and Hour Act, and the unpaid wages or, you know, benefits that you were to have given to an individual that you misclassified would come back, and you could be held liable for those. Our statutes also provide that any interest on unpaid wages would be due at typically the legal rate of about 8%. Damages can be doubled by the court. The court has discretion to do that, and they have discretion to award a prevailing plaintiff their costs and their attorney's fees. So if you got into protracted litigation and you took it all the way to the end, you could be facing not only paying your own attorney's fees, but facing the attorney's fees of the person who was misclassified. There's actually sort of a burden shifting under the Wage and Hour Act where, although typically the plaintiff in a case who's filing a lawsuit against their employer has the burden of proving whatever it is they're arguing, once they have made have established that they have proven their case, the burden then shifts to the employer to demonstrate that they did not act in bad faith. If they acted in good faith in making their decision, when an employer determined that the classification of an individual was appropriately as an independent contractor, then you as the employer would have the burden of demonstrating that you acted in good faith in making that decision, or that you had reasonable grounds to believe that it was not a violation of the law to make that decision. So that burden shifts to you, otherwise you're going to be stuck. And those, but a court can still, in its discretion, even if you did act in good faith, they can still double damages, award liquidated damages, and it's hard to reverse those. There may be, unpaid tax contributions, IRS penalties, and interest, and certainly in North Carolina, at least, our laws, there are no safe harbors for any misclassification. So, the best you can do there is again, do anything you can to demonstrate that you're acting reasonably and in good faith.
And I think that's a good point. That brings us to sort of what should you be doing, given these risks and this increased focus on employee versus independent contractor. As you said, if you've taken reasonable approaches, maybe you've got reasonable procedures. Ideally, you've got a process in place where, when you're hiring for a new position or creating a new position, it's been reviewed by your outside consultants or legal advisors. You actually have a process where you analyze whether or not this fits, into employee versus independent contractor. What do you think, Candace? Are you seeing more people put in place sort of procedures or processes?
I think and I hope that that's what they're doing. Again, a lot of times I get involved at the litigation stage where it didn't happen.
You're involved more with the ones that haven't, yeah.
But I have seen a few, and that's always, from my perspective as a litigator, looking at that is what could we have done to prevent this, or what can you do to prevent this in the future? And I think Ann is dead on target there, because those are famous last words for a litigator, because we always say, if you had just done this, or if you had just done that at the beginning, if you had thought this through, or given it thought, or given it time, and just asked someone, we'd be in a whole lot better shape now, which is, only worth the words that I have to speak it at that point.
I think another one, Candace, would be consistency. I've seen employers, even just in recent months, where we've been reviewing their procedures, or kind of asking them questions, and their answer is, well, it depends on whoever I hire. We decide whether or not they're going to be hired as a 1099 or W-2. So they might have 5 people in the same position, and 3 of them are employees, and 2 of them are 1099 contractors, just because, well, that's what they agreed when they hired them.
Absolutely, absolutely. I think that's right, and I think that would be perfect fodder for a plaintiff's attorney, in a trial. And even if you have, how you classify, that just sort of goes the whole point. How you particularly classify someone just because you have a feeling, or this is how you've always done it with them, is not going to carry much weight, and that is not determinative of the true classification.
Yeah. So I think it's review your procedures. Make sure you have consistency. If you have 2 people in the same or very similar positions and they're not being treated the same way, you've got an issue you definitely need to address. I mean, maybe there's some differentiating factor, but you want to be sure, because that's already going to look bad for you. On the bright side, from at least a federal perspective with the IRS, if you do discover that you go back and review some of your positions and you find, there's one group, I don't think we've been doing it right. There is an IRS voluntary classification program that lets you correct on a going forward basis, and the cost is minimal. You don't end up owing any penalties, and what you have to do is you have to go back and pay what equates to just over 1% of the wages that were paid to that reclassified group over the past year. So, let's say you've been treating them wrong for 10 years. The fact is you can limit your cost to just over 1% of 1 year's wages and sort of get a blessing going forward, at least for IRS purposes. That may not necessarily protect you from, North Carolina or, FLSA purposes, but, it at least checks one off the list. I think let's move on to talking about exempt versus non-exempt, which is the other big area of misclassification that we're seeing. And this one's been around for much longer, but I think it's been in the press so much because of the recent Department of Labor regulations. And we'll kind of touch on that. I'll give a little background here, and then Candace can talk about sort of what North Carolina is doing. And as all of you are probably intimately familiar with, for Fair Labor Standards Act purposes on the federal level, we have exempt and non-exempt classifications. Your non-exempt are the folks that you're going to have to pay overtime to if they work in excess of 40 hours in any work week. But the key here is who is exempt versus non-exempt. If you are breaking your people into exempt versus non-exempt based on whether or not you're paying them a salary, that is not correct. A non-exempt person can be paid a salary. The salary does not determine it. If a non-exempt person was paid a salary, you would just have to break that salary down to figure out what their overtime rate was. But don't use their rate of pay, whether they are hourly or salaried, as the determining factor for whether or not someone is exempt or non-exempt. Your exempt employees are going to fall into, just as background, they're going to be, your exempt are always going to be salaried. So that meaning they're paid a predetermined or fixed salary that's not subject to reductions because they, left early some days or the amount of work they performed. They have to be paid at least a specific salary threshold, and this was the big focus of the DOL regulations that failed, for lack of a better term, earlier this year. Currently, it's $455 per week, or $23,660 a year. And then, in addition, they also have to qualify as, for one of these exemptions, they either have to primarily perform executive, administrative, or professional work. And you'll see on the slide in front of you, executive, we're talking about a CEO or director, administrative, manager or supervisor. Professional is the one that, for a lot of folks on this call, is going to be the exemption that applies to a large number of your workers. These are so-called learned professionals. Practice of medicine fits into this, and their primary duty is supposed to require advanced knowledge and exercise of discretion and independent judgment. It's customarily obtained by a prolonged course of specialized intellectual instruction. You can see where, especially some of your physicians and nurse practitioners, registered nurses are going to fit into this category in most cases. But note, there's also some smaller exemptions. Executive, administrative, and professional are the big ones. But you've got highly compensated office workers, people that do non-manual office work and earn $100,000 or more, and satisfy some other requirements can be exempt. Outside salespersons can be exempt if they satisfy all the requirements for that particular exemption. So, it's important that you go through each of your positions, and just like we talked about earlier with independent contractor versus employee, it's important that you, figure out, have you looked for all the different exemptions? Are you just instantly classifying someone as exempt without thinking further about, the impact? And the reason it's important is because, there's certainly been some recent federal focus on overtime. Everyone heard about the DOL issuing those overtime regulations last year, and then everything happening with the Trump administration coming in. I mean, what has happened is that those regulations would have doubled the exemptions from $23,000 to $47,000 for the salary threshold. It actually would have also increased the highly compensated employee exemption from 100,000 to 134,000. But the point is, those regulations were challenged by the courts. There was preliminary injunctions issued. The DOL officially abandoned its defense of these overtime regulations in late June. There's technically no final decision by the court, but what we expect is the DOL to come out with something more middle ground. The current Labor Secretary, Alexander Acosta, has said that the prior administration went too far in issuing the regulations that it did. You know, the talk in some of the articles and from some of the insiders is that they expect an increase in the salary threshold, but not so drastic. The DOL published a new request for information, so that's sort of the first indicator that, okay, they're looking to do something and they're trying to revamp this. The comment period actually just ended about a week ago, September 25th. So, you know, we can expect over the coming months here to get something, to see something from the DOL, some sort of probably modified regulations that we'll all have to analyze and figure out again. But let's focus a little on North Carolina and sort of how North Carolina's approach might be the same or differ.
Yes, the North Carolina Wage and Hour Act, as I mentioned before, largely track the FLSA, of course requiring those employees who are non-exempt to be paid time and a half when they are working overtime over 40 hours per week. The determination, you know, in this state, and I think it's the same, you know, with the federal law too, it is really about the specific facts of a case and what an employee actually does in their job that's going to really determine whether they are appropriately classified as exempt or non-exempt. You can't just go by the title, you know, but just much like Ann was saying, just the title you put on it. You can't just go by the title of the job or, you know, the job description that an employer might write out and put in an employment manual, excuse me. That is not going to be, you know, the determinative factor as to whether or not, you know, in this state an employee is properly determined to be exempt or non-exempt. I think that from what I've seen, and I think this is true in both federal cases and in state cases that we see, the devil is really in the details on this. I think how you classify, particularly for that learned professional exemption, I think it's been my experience, I don't know if Ann would agree with this or not, but that's kind of the hardest one to really define and parse out. In some ways, that or perhaps the administrative, that might be another one that's one of the harder examples to sort of parse out.
Yeah, I would agree. You know, there's certainly people who clearly fit into it, but there's a lot of gray area.
I think that's very fair, and you know, I think that it's because you know, for example, I've seen some cases where whether a person qualifies as exempt or non-exempt, they were put in the exempt box because the employer said this person is a learned professional, and it comes down to perhaps does the person have the right academic background, are their degrees appropriate, or did they have advanced knowledge in the right field and for the job that they were actually performing, and what were and of course, again, under, kind of lifts up the hood and looks underneath to see what were they actually doing, not what were they described in the manual to be, projected to do, or what we categorize as particular, individual to be performing for services for this organization, but what did they actually do, and sometimes that, another sort of piece of that is, an exempt employee is going to be someone under the learned professionals exception who primary duty, is performing work requiring that advanced knowledge and that sort of prolonged specialization, and to what extent did that job require that person to use discretion? To what degree did they have to exercise independent judgment? And those are very fact-specific inquiries and factors that have to be taken into account when making sure that, a designation is appropriate as to whether that person can be exempt or non-exempt. And I think that again, North Carolina's going to track the FLSA on that and model it on that act, and you have to be very, very careful and early on, analyze and evaluate your different categories of jobs and the duties, and really look hard to determine, exactly what people are going to be doing in that job to decide, is this person appropriately categorized as exempt versus non-exempt. And the risk again is, you could be looking at some substantial monetary liability for unpaid overtime, and as Ann mentioned, not just to an individual, but to an entire class. And the FLSA has a specific provision that allows, it's called a collective action, basically the same thing almost as a class action, where you don't just, if you misclassify, a particular category of employee as non-exempt, or excuse me, as exempt when they really should be non-exempt, that you could be looking at a large class of employees or former employees who you're going to have to go back and repay wages that were due to them. There again, you could be also potentially facing double damages, attorney's fees, costs, just your own cost of litigation as well. Employee benefits may be due, either sort of the same thing that we talked about before. And I do think we're seeing more proactive cases by plaintiffs' attorneys. Lawsuits are increasing. It seems like the sort of the plaintiffs bar, as we call it, they tend to kind of latch onto these different types of lawsuits. For a long time, there were the mesothelioma cases, and then there were the mesh cases, and you're seeing sort of groupings, and I think you're kind of starting to see more plaintiffs' attorneys turning their focus to employees and misclassification. So I think it's to be expected we'll see some more of that in the future, and that can get pretty expensive pretty quickly. What should we be doing? Again, reviewing your positions, reviewing your classifications, looking hard, again, not just what you have written on paper, but thinking hard about what you really expect that particular employee to do in that role, and kind of looking under the hood of that, and making a fair determination of that, if that person is truly an exempt position or a non-exempt position, and correcting those errors before it gets to the point where someone believes they've been treated unfairly and starts a lawsuit. And because even if it turns out that they were wrong and you did everything correct, it's still an expensive and long and stressful process to get there to the end, and keeping appropriate and very detailed records of pay is not, first of all, not only required, but it's also very important to help defend yourself if there ever is a question, because the burdens on the employee making a claim under these kinds of statutes are also pretty high, and so you can really hold them to task on that. So the better your record-keeping practices and your history are, you are establishing not only that you act reasonably or in good faith, but that you also kept detailed records. And I'm sure Ann has some additional keys to thinking about ways to sort of thwart these problems before they start.
Yeah, I mean, I definitely think that when you're reviewing, in fact, I had a client last week that came in and they had started reviewing their positions, and this goes to the consistency. It is so important that whatever you do, you act consistently in how you're applying these rules. That's going to go a long ways to supporting, the positions you've taken, and I think, as Candace would say, a good defense. We had a client last week that came in and they had, 4 people in the same position. 3 of them were non-exempt and 1 was exempt. It made absolutely no sense. They were doing exactly the same job. It was just, well, the woman had been there longer than the rest, and somewhere along the way, someone changed how they were approaching it, but they didn't go back and make sure that they were treating everyone consistently. So that's, really important. And I think when you see these new rules come out, you know, expect there's going to be a lot in the press. You'll be tired of hearing about it. But it should be something, you know, expect that over time the exemptions, the salary thresholds for the exemptions are likely going to go up. I mean, we don't have a crystal ball, so who knows. But it'll be more, that will be a good time if you didn't do it last year when the last round of regulations came out. This will be a good time to plan to just sit down and, you know, just take a few hours and review the positions you have in place. And you'll need to do that anyways just to figure out how your people fit into the new regulations when they come out. But, you know, it's prudent, and it's going to save you in the long run. Okay, Gary, do we have any questions?
Yeah, this would definitely be the time for, if you have questions, to key them into that Q&A window. One question I have is, I think this actually relates to both the independent contractor issue and the exempt, non-exempt issue. So how far back can a former independent contractor or a former employee pursue action if they feel like they were classified incorrectly in either case, independent contractor or exempt, non-exempt?
Candace, you want to address that from the North Carolina side?
Sure. So under North Carolina law, under the Wage and Hour Act, which we'd primarily be focused on, there's a 2-year statute of limitations. So they would have to, you know, within a 2-year time period, so it's not going to stretch back too long.
Yeah, and the IRS, sorry to say, can actually go back further. Unfortunately, fortunately or unfortunately, depending on which side you're on, you know, when it comes to taxes and compensation, you know, we can be looking at on the tax side, we can be looking at anywhere from 3 years from when the employment tax returns were filed, and possibly 6 years if it's something that they were to establish was willful. So, you know, it's not a forever. It's certainly, you know, not going to be, for any of you who've ever had employee benefit plan corrections or things, you know, they'll tell you that the IRS wants to see you go back for all of history. But it's certainly a significant look back.
Very good. And there was mention of, under the independent contractor section, there was mention of the voluntary classification settlement program with the IRS. Is that a program that you would recommend if a practice were interested in that or needed to pursue that they would still need attorney representation, or is that something employers can independently and address or delve into?
Ooh, that's always a tricky one, right? I mean, I think that, and Candace, please speak up if you disagree, I think it's a good idea to involve an attorney at least on a limited basis. You can still file under that yourself, but I sure would want to know if I'm going to go in and file that I'm not going to have a footfall, that if I go in and file, it isn't going to open up. You know, you don't have to file for all your employees. You know, if you just discover one group of employees, this one looks like maybe we've done it wrong, fine, you can go in and file. You know, certainly don't need to have an attorney in order to be able to do that. But what you might want to do is at least talk with your outside attorney to make sure you have them look at your employee population, and is there anybody that's similar, or, you know, because you can bet that the IRS, there's a higher likelihood the IRS, you know, may ask about similar positions or other people that you employ, and so, you know, you're going to want to make sure that you're protected there.
Great, thank you. And there was a question here, will there be a PDF copy of the presentation available? You should now have access to download the file that you've just seen today. You should see that on your screen now. We will also post the full audio-video recording on the NCMS Plan's YouTube channel in the next, I would say it'll probably be up there by Monday or Tuesday of next week, so you'll have that available as well. I think that is the end of our questions. Anne and Candace, I really do appreciate your participation today. It was great information, a lot to cover, but I think those are two really important topics. I appreciate your time. And for those attending, we will likely have another one in a few months. We have planned these employment law webinars on a quarterly basis, so watch for an invitation to the next one. If there's a topic, employment law topic, that you would like to see us address next time, please email me. We are open to your suggestions. I know Anne and the team over at Nelson Mullins have partners that can address, I would argue, probably any employment law issue you could throw at them. So feel free to email me directly, and we will look forward to hosting another webinar in the near future. Thank you so much, and have a great afternoon.
Thank you.
Thank you again for joining us today. This does conclude today's conference. You may now disconnect.